Representing a child in a lawsuit for injuries or for a physical assault or worse, for a sexual assault, requires not only that you wear the hat of a lawyer and litigate the case effectively and investigate the case thoroughly, but you also have to make sure that the child is insulated from any additional negative effects, additional trauma, additional anxiety, additional unnecessary exposure to things they don't need to be exposed to because the lawsuit is occurring. You want to ensure that they receive justice. You want to make sure that they and their family are represented properly in the legal system, that ultimately the case reaches a successful resolution. But at the same time, you have to be very sensitive and very cognizant of insulating the child from exposure to aspects of the litigation that can be traumatizing and an additional source of anxiety and stress. You know, we work very hard in those cases to gather all the information we need to effectively represent the client and her family or his family and present the case fully, comprehensively in court, while at the same time not doing anything to further traumatize the child or expose the child to recollections of the incident or the injury or parts of the legal process that they don't need to be exposed to, because it's just going to create more anxiety and more stress and add to the initial trauma. So it's a balancing act, because you want to make sure you're thorough and you're uncovering every stone and learning about all the little ways that the child has been affected, that the family has been affected. But you also want to keep them removed. You also want to create some distance between the legal process and the child and the family, so that they are not needlessly exposed to something that's just going to create more stress. It's just going to cause them to relive the trauma of the incident. So you have to balance those two things, making sure both are done right.